Okay, let me just make sure I'm all set here. All right, good afternoon and welcome to April's rendition of LOMAD TV. And this month we've got a LOMAD holiday special for you all. We're going to be hunting for Easter eggs, and I'm joined today by my colleague and friend, James Cousins. Welcome, James.
And fellow rabbit.
And fellow rabbit, correct. Shout out to James for providing the bunny ears. I think it's a nice touch. I wish we were able to get a virtual background of the bunny trail, but I'm not the most technologically savvy, so we'll make do with the bunny ears. For those of you who don't know me, my name is Brendan Shannon. I've been with the firm for about 1.5 years. This is my second time presenting Lawyers and Friends, and I'm looking forward to going over some Easter eggs in a comp case. And what we mean by that is little things that you can catch when reviewing a file that can lead to big results. So we're going to start off with the theme song, and then we'll get right into the presentation.
Yeah.
Things keep changing and never for the best, at least not for you. Rearranging rules that we cannot contest. What can you do? Don't go crazy when the judge says your claimant had a good day. When things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. Gonna help you through it all the way.
All right, so let's get right into it. To start off, we do have our disclaimer here. This is merely instructional and not intended to be legal advice. If you'd like to receive a copy of today's presentation, you can contact our office, and we do have contact information at the end of the presentation to do so.
And let me just add that this presentation does not constitute the creation of an attorney-client relationship, although you would be wise to retain us as your counsel.
Correct.
Because we are the very best. I don't know if I'm allowed to say that, but I believe it. It is a belief. It is not a fact. We do know the difference.
Yeah.
All right, let's talk about Easter eggs. And I just want to add when we start, this was a great idea. And the concept is, so that you know this, is that Easter eggs, you hunt around for something and they mean something more than what they are. Easter eggs are also something that you find hidden in movies. You've probably heard the phrase Easter eggs. They're usually throwbacks to previous versions or references to books that predated the movies, something that has significant meaning that's kind of hidden in a scene. Well, what we thought about was the fact that there are Easter eggs in workers' compensation claims. And sometimes you look at a claim and there may be an Easter egg in there, and you need to know what you're looking for to find it. And if you find it, it can lead you down, as Brendan pointed out, the bunny trail to great results. So just to allay any confusion, we're not actually hunting for real eggs. We're hunting for the proverbial abstract Easter eggs.
Although there were some Easter eggs hidden in our office around Easter, if I remember correctly. But
yeah, it took me 2 weeks to find one.
So the first Easter egg would be where the AWW is set without prejudice, and this one was provided to us by Melissa when we were compiling, the Easter eggs in comp claims. All the attorneys submitted things that they've come across. So the scenario here would be that the AWW is set without prejudice, maybe per the Froy or a Sroy at the beginning of the case. And this is pretty common. Sometimes there's just not a C-240 in the file. Maybe the employer's taken some time to produce one. Maybe it's a controverted claim, and we have a position that there should be no AWW set because the case isn't going to be established. So there's no C-240. Lo and behold, the judge sets the AWW per the Froy, and what they'll do is they'll set it without prejudice, meaning that it can be corrected once the evidence produced, but for now, basically as a placeholder, the AWW is set as it was estimated by the adjuster. And what sometimes happens is that a C-240 will then be produced because the judge will make a direction that a C-240 be produced when they set it without prejudice. but then, hearings happen, the case continues to get litigated, and the AWW is never readdressed. So this can become, quite the problem in some instances, and can be pretty relevant, especially in situations where a claimant alleges something like reduced earnings. Now, if you were to take a look at the C-240, now this would be the Easter egg here. You're coming in to litigate reduced earnings. You notice that the AWW is set without prejudice per the FROI, and then you see, oh wait, there's a C-240 in the file. I'm going to check this out. You look at the C-240 and it shows significantly lower AWW than that, than what the judge set it at without prejudice. And obviously, in a reduced earnings situation, that can be highly relevant. So just the basic law for calculating AWW, a 6-day worker is generally entitled to a 300 multiple, 5-day worker to 260 multiple. It's a little more nuanced than that. And then in some instances, there's a 200 multiple if that doesn't apply. There's not a similar worker payroll. And then occasionally a straight divisor would apply where the claimant self-limited his or her time. But that's just really to provide a basis for something that most of you probably all know pretty well, which is how to calculate an AWW. The important thing to note with a situation like this, where the AWW is set at the onset without prejudice, is that it can always be corrected. So there's a couple ways that this can be done. If it was set by the board, you may need to apply to the board. If it was definitively set and never appealed, or it can occasionally just be corrected at the hearing if it was merely set without prejudice. So don't ever let a judge tell you that it was already set without prejudice 3 years ago. I'm not addressing it at the time of reduced earnings at the end of the case. So here's just the general law on reduced earnings. Claimant's eligible for a reduced earnings award when they return to work at a lower wage rate, and such lower wage rate is determined to be caused, at least in part, related to their disability in the comp claim. And the board measures reduced earnings as 2/3 of the difference between the post-injury earnings and the pre-injury AWW. This is why it's so important to calculate the AWW based off the C-240, especially in this case, where we found the Easter egg that, lo and behold, the C-240 reveals a lower AWW than what the claimant's been being paid at. So what's the result? Get to the LWEC trial, claimant's seeking reduced earnings, and we're able to successfully reset the claimant's AWW to a lower number than it had originally been set without prejudice. Suddenly the claimant has no longer has a claim for reduced earnings. So the judge set the claimant's LWEC, but did not award the claimant any further indemnity benefits where she could no longer demonstrate reduced earnings. So basically, off of something as simple as the C-240 getting properly applied, we were able to secure a massive win, because if the AWW had remained unchanged, we would have been liable for continued reduced earnings. So that's a huge Easter egg. It's one that comes up fairly frequently. So it's always important to look to make sure that the AWW was set definitively via a C-240. Next up.
That's a perfect example of an Easter egg, everybody, is that, any number of attorneys might have examined this file and saw that the average weekly wage was set without prejudice and that there was a C-240 in the file. The question is, in this case, quality of counsel. Is your counsel going to stop and say, okay, well, I'm actually prepping this case for LWEC and a reduced earnings claim, but are they actually going to stop and look at that C-240 and go, you know what, I better address that too, right? Or are they just going to assume that maybe it's never been addressed because it's still correct based on even though it was set without prejudice, or maybe it should be higher, but it's got to be calculated. Every loose end has to be tied up. And this is an excellent example of what I think is good claims handling.
Yeah, and going along the lines of reduced earnings, next up, this is actually provided by you, James. This would be where reduced earnings are under $600 a week.
Oh yeah, let me talk about this one. I want to talk about this one because this one grinds my gears a little bit. So we now live in a world with a minimum wage that's pretty high. It's $13 and change here in upstate. It's $15 downstate. And basically what that means is, and even upstate, I mean, even though the statutory minimum is $13.20, most jobs are now being advertised at $15 an hour starting wages, right? So if you take 15 times 40, that's $600 a week. So if you're examining a reduced earnings claim and that person is earning $600 a week or something close to it, they're pretty damn well close to making minimum wage. And a lot of these claimants prove through their production of RE that they're not working full time. So if somebody comes to you and says, well, I make $300 a week, you can now be sure that if they're making $300 a week at $13.80 an hour, they are not working 40 hours a week. They're working something closer to 20 hours a week or 25. And because there's case law that says a reduced earning has to be causally related, you now have evidence that a claimant is working part-time. And if a claimant is working part-time, there are tons and tons and tons. Literally every year, there's 2 or 3 cases from the appellate division upholding board's rulings denying an RE award on theories such as the claimant is working part-time without a medically imposed part-time work restriction, right? That demonstrates that if the claimant is losing wages in the form of a reduced earning, they're doing so for reasons unrelated to their disability. So it's a wonderful little Easter egg that before you start doing all the math and get caught up in the idea that, okay, I'm going to do all my math, calculate the reduced earning award, you need to stop and examine what the data is showing you more obviously, which is this claimant's probably not working full time. And rather than proceeding to allow the award, you're going to stop and request testimony from the claimant before allowing the reduced earning award. And you have good reason to indicate to the judge when you're requesting that testimony why it is that you need that testimony. I mean, it's just a great Easter egg. And here's 2 examples of great cases. You know, if you're working part-time without a part-time work restriction, you know, you don't get an RE rate. So, you know, I think that these are 2 older decisions, but you're going to find them from 2019, 2020, 2021, and I'm sure there's going to be a bunch in 2022, all on the same topic.
Yeah, and I think what's interesting about these cases, I think it was the first one listed. The claimant was supposedly working well over 40 hours a week, but making extremely low wages. So basically, the board looked at it and realized, obviously, these low wages aren't related to the disability, and for whatever reason, the claimant's getting paid at an extremely low rate, or the employer is limiting the hours in some way that's not related to the disability. So it's one of those things, like you said, James, that it's not obvious, and that's why it's such a great Easter egg. But once you kind of have those numbers in your mind, $600, $530 or so, I think it opens up this issue in a lot more cases than you might originally realize.
Yep.
Yeah, so in that case, claimant should not receive reduced earnings. Sorry, Mr. Claimant.
That's claimant's attorney.
Yeah, it's claimant's attorney.
Yeah, and he's got a headache because he hasn't had to think that hard in years.
Yeah, and now he's not going to be. So the next one, I'll be honest, this is not a scenario that I was aware of really until Shannon Mackey brought it to my attention. And once again, we're going along the lines of reduced earnings, and this is reduced earnings and pre-tax deductions and how they interact. So the scenario here is that when we're setting the claimant's AWW, the claimant produces his or her W-2, and it's based off of the claimant's gross earnings. So that's the scenario here. That's the case. In this case, that's how the claimant's AWW is set. However, then at the time of permanency, when calculating the claimant's wage earning capacity to assess the claimant's entitlement to reduced earnings, the claimant suddenly produces evidence of their gross earnings after taking pre-tax deductions. An example of pre-tax deductions would be, deferred compensation, retirement, and employee contributions towards health insurance. And that's not an exhaustive list, but as you can imagine, that can be a pretty high total that's going to substantially reduce the claimant's gross earnings. Now, there's case law on this, and basically what it says is that when the AWW is set by the pure gross earnings on the W-2, then when you're calculating the claimant's entitlement to reduced earnings based on their wage earning capacity after the disability, you need to compare their gross earnings at that time to the gross earnings beforehand. You're not comparing the gross earnings post pre-tax deductions to the pure gross earnings pre-tax deductions. So basically, the idea is you're comparing apples to apples, or oranges to oranges, not oranges to apples. And it might sound a little confusing, but the idea is, I tried to write it a little bit more clearly here, is that the claimant's post-disability gross earnings before taking pre-tax deductions will be considered alongside the claimant's gross earnings in the year immediately preceding the date of accident to calculate the claimant's reduced earnings. So it's something to look for. As you can imagine, it's a way that claimants can basically try and fudge the evidence to their benefit. And one of the things that can reveal this, and I think this is what Shannon said in the case that she was dealing with, is that the claimant was receiving reduced earnings for such a long period of time with just no change, absolutely no change. And that sort of triggered an investigation, which led to that ultimate result of realizing that this was one of those situations where the claimant was, getting a little shady with the pre-tax deductions. All right, so next up, this is a juicy one. So sometimes Easter eggs can be like manna from heaven, fraud from the clouds. And I think an important thing to note is that little things can reveal fraud. And frequently claimants or their attorneys will submit evidence on a completely, minor issue. It could be something like concurrent AWW that triggers an investigation into whether they are committing fraud. And this scenario, which was also provided by Melissa, is one of the best examples you could hope to find of this type of thing, because I don't think there's any way that the claimant's attorney could have realized that they were running into this issue here. So the scenario here is that the claimant's operating a business while on comp. However, of course, we don't know this when we first start litigating the case and while the case is going on, but it eventually leads to a potential fraud claim. So the claimant's out on comp, and the claimant has a spinal cord stimulator. And he sent his attorney the warranty information for the spinal cord stimulator because the carrier is responsible for maintaining the spinal cord stimulator, the attorney forwards the email to the carrier. And in looking at the case, we realized...
Hey, Brendan, can you reset your microphone? Maybe it was just we were getting some real strange noises there, some strange feedback. Sorry. Oh, now it seems to have stopped. Okay.
But now?
All right. No, we're good.
Okay.
Sorry.
Yeah. So we get this information about the warranty. It's forwarded by claimant's counsel, and it's an email from the claimant. And claimant's email address, and this is not claimant's exact email address, fairly obviously, is blah, blah, blah at woodworkingyada.com. Now, I'm not sure if that domain's been bought, but I'd be curious to see what woodworkingyada.com brings up. But anyways, the key thing here is that the email address had woodworking in it. It was woodworking at wherever.
It literally had the word working.
Right. Well, work was spelled differently, but it was W-E-R-K.
Well, close enough.
Yeah.
That's how claimants spell the word work.
Yeah. And this triggered an investigation. You see an email like that, it's going to make you sort of question what's going on, especially where the claimant was out on comp for work that wasn't woodworking. So this scenario gets weirder. So in this case, Melissa searched the Oklahoma Business Certificates database and was able to find that the claimant was affiliated with a company that sold custom BDSM props. Now, that's not a typo. This is a family show. It's the Easter egg hunt, so we're not going to get into that. But a social media investigation did eventually reveal that the claimant had a YouTube page where he documented his process for making flogs which he sold through the BDSM company, which was called Woodworking, I believe, and also through Etsy.
No, it was Masters Tool Chest Club.
Masters Tool Chest Club. There you go. So, I provided the statute for fraud, which the basic idea is that where a claimant, knowingly makes a lie, commits lies about something that's important to the case, and usually the idea of important to the case would be that is for the benefit of receiving comp benefits, that can be a fraud claim. And in some instances, fraud doesn't have to be an overt lie, but it can be an omission, which in this situation would be the case where if a claimant's collecting comp and they're signing a check and they're out on total, they're signing a check saying that they're totally disabled and they're not working or anything like that, while also collecting benefits that say that they can't work at all. And when fraud is found, there can be a finding that the claimant is then disqualified from ever receiving indemnity benefits ever again. And sometimes it's actually a fairly common practice for the judge to direct the claimant to report a return to work. And sometimes they'll conduct a colloquy at the hearings where they'll ask the claimant before they make an award at total, are you working? Do you have a business on the side? Are you volunteering? And if the claimant says no to those things and they are doing any of those things, then we have a fraud claim. So the result here is that the claimant's found to have been operating a business while collecting comp benefits at total, despite denying work activity, and the claimant's banned for life. And this is, as juicy of an Easter egg as you can have, because not only is the content of it sort of salacious, but it's really just all because of an email address. So this is just another example of why it's important to look closely at things. If red flags are raised in your mind when you're looking at a case, investigate. It oftentimes won't lead to anything, but sometimes it'll lead to a juicy Easter egg. All right, so next up we've got a situation where the claimant's collecting unemployment. Now, this is something that comes up fairly often, and it's usually not obvious the way it comes up. It's the type of thing you'll find when you're reviewing the file in preparation for a hearing. Maybe the claimant will mention it in their testimony, or otherwise it'll get mentioned at a hearing. Maybe claimant's attorney will tip you off to it. I mean, it's the type of thing that you'll find out about occasionally. It's just a matter of how. And the scenario would be that a claimant's receiving benefits at total, but you discover that they're also collecting unemployment. Now, why does this matter? So under section 591(2) of the labor law, no benefits shall be payable to any claimant who's not capable of work or who is not ready, willing, and able to work in either his usual employment or, basically employment within his or her restrictions. Now, notice I underlined who is not ready, willing, and able to work. So if a claimant's out at total, meaning they can't work at all, they can't also be ready, willing, and able to work. At least, that's how the law sees it. So this raises an issue, and what will happen is the claimant should not be receiving benefits at total. And at the very least, even if the awards continue at total based on the medical, the claimant shouldn't be considered totally disabled for PHP purposes, and PHP would be protracted healing period purposes, which when dealing with scheduled loss of use, the statute provides a set number of weeks for each extremity that is considered a normal amount of time for the claimant to be healing. And if they exceed that number of weeks, those weeks are then tacked on to their SLU award, which can actually result in a lot of extra money due to the claimant, compared to what just the base SLU award would normally yield. So this Easter egg can be very, very beneficial, because you can then say, well, sure, maybe they have 5, 10, 15 weeks of PHP if we were just to look at these TTD awards as is. But, it came out during the litigation that the claimant was also collecting unemployment during that entire period. He clearly was not totally disabled, at least as it's considered in comp, not totally disabled, where he was affirming that he was ready, willing, and able to return to work at any time. So It's an important thing to look for. It can also prove relevant in situations where the claimant's claiming that they don't need to demonstrate attachment to the labor market. Well, if you're, unable to attach to the labor market, why are you signing this affirmation when you're collecting disability?
I actually had this come up as a young attorney in a different context. As I made some arguments at a hearing about periods of disability, and my opponent, claimant's counsel, conceded substantial periods of disability at a partial rate consistent with our IME, and didn't really say too much about it. Just said we don't have an issue with that, and I was so confused. I came back to the hearing. I didn't want to admit that I didn't know why he would do that by asking the claimant's counsel. So I came back and I asked Melissa, I said, why the hell would they give up on all that? And Melissa thought about it for a minute and said, claimant's obviously collecting unemployment and didn't want to go through the rigmarole of risking being charged with unemployment fraud by trying to claim total disability benefits and comp. So it sometimes leads to odd results. It sometimes actually makes our claims easier, and as far as the claimants are concerned, they do better because they can make more money with combining the benefits.
Right.
But it's also a concession that the claimant has to look for work. If they argue in the comp setting that because they're, quote, still employed by the employer, that they're immune to a challenge on labor market, well, if you ask them the question, did you apply for unemployment, and did you certify to them that you're searching for work or ready, willing, and able to return to work, why are you making this argument in comp court that you have no expectation, or you have an expectation of returning to work? Otherwise, you should be demonstrating attachment here too. That I haven't gotten a great amount of traction with that, but it's definitely a good argument to make when the claimants raise that issue.
Definitely. All right, so moving on. Next scenario, so it'd be claimant's totally disabled from his or her, quote, at injury job. Now, this is very common. And it's the type of thing that even if it's not in the record, just based off of the treatment notes, it's something that you can frequently bring into the record through testimony. So what we have here is claimant has medical evidence of a total disability. The C402 lists the claimant's degree of disability as 100%. However, the narrative report states that the claimant's disabled from his at injury job or occupation. And it's not always necessarily that language, but it's something along the lines of, claimant's totally disabled from his employment as a construction foreman, or claimant is unable to perform his job as a welder. Or in some scenarios, instead of it being in a narrative report, the treating doctor will testify that his or her TTD opinion pertained to the claimant's at injury job or occupation. And that's why I say that this is something that you can sort of bring into the case, because it can prove beneficial, at least as, a part of your argument on the issue of degree, or that the claimant should be less than totally disabled. So, I know I personally, in all of my depositions on degree of disability, I simply ask, doctor, you found the claimant to be totally disabled on such and such a date, correct? Yes. And that was from their at injury employment as a welder, correct? Yeah, it was from that employment. And very rarely will they qualify that, no, it was from all employment or otherwise. And actually, occasionally they'll say, yeah, he's totally disabled from that job, but he could probably do some sort of sedentary work. Now you can see how that could be helpful to our situation. So I managed to find some case law here. It's one of those things where it's such a well-known part of workers' comp that it's not really in the case law as much, but it's the idea that a claimant's degree of disability is not based on their ability to perform their at injury employment. It's based on their ability to perform any employment in the labor market. And I think probably the most obvious way of thinking about this is that when litigating labor market attachment, it's not, are you able to perform the job that you were performing or whatever? It's, can you perform work within your restrictions? So I just managed to pull a little case law that has language stating that this is the case in comp. So the result in this situation will depend, but like I said, it puts us in a good spot, and it gives us plenty of building blocks for an argument on degree of disability, especially against temporary total finding.
There goes that weird, okay. Sorry, there goes that weird sound again. I'm sorry, there must be like some intermittent feedback coming in from your mic.
Yeah.
Go ahead. Sorry.
Okay. So in this scenario, we could litigate degree of disability where we might ordinarily not. So in some situations, we might say, stipulate to a split between the doctor's decision, opinions on degree of disability. They're, within this percentage, the judge is probably not going to side with the IME for such and such a reason. Such and such a reason. Let's stipulate. Well, when we have this evidence here that the doctor based his opinion on the claimant's ability to perform his at injury work, then we might be more inclined to actually litigate degree of disability where we otherwise might look for an agreement. The other thing we could do is we could question the doctor on whether the claimant's less than totally disabled from all work available in the labor market. Now, this is somewhat situational. I mentioned how, in all my depositions, I asked that question of, was that from their at injury employment? Usually they say yes. Sometimes you want to expand on it. And this is what I mean by it being situational, is that you kind of base it off the doctor and how the testimony is going. You might think that this doctor is kind of leaning towards he's not totally disabled from all work. And you'll be like, oh, okay, so he could do sedentary work, right? He's able to do this and that and the other thing. He could do sedentary work, right? Yes. Some situations you just know the doctor will basically correct what he said or what he reported, and you don't want to give them that opportunity, so you won't expand on it. And the other thing is we could argue against awards at total. Like I said, the standard's not whether the claimant can perform his or her at injury job. It's whether he or she can perform any work. So this is a nice little Easter egg, and it's one that you can almost create through testimony. And I think it's a useful building block in a case when you're litigating degree of disability. This is another common one that I think is very, very useful. And it's kind of a fun one to get. So this is where a claimant leaves blank the question asking whether he or she had a prior injury to the same body site when they're completing the C3. So as you know, the C3 is the employee claim form. It's basically in most instances what starts the case, and the claimant signs the C3 affirming that everything on there is true under penalty of perjury. And you have a case and you're looking at the C3, everything's filled out except the question asking whether the claimant had a prior injury to an overlapping site or a prior illness that relates one of the injury sites being claimed.
Hey, Brendan, do you remember the case law that we reported last year where some claimants' lawyers tried to get cute with like answers to these questions?
Yeah,
like to give really like sort of vague and non-specific, and they were penalized by the board. Oh my God. Yeah. It was great.
Yeah. So, I mean, as you can imagine, when we see this, what does that trigger for us? Well, we know that they don't want to answer yes, but they're trying to avoid committing fraud by overtly stating no when they know it not to be true. So what should we do? Well, first and foremost, and this is where, we can have really great synergy between, our office and our clients, is we can get an ISA report. And the ISA report is going to tell us right off the bat if the claimant had any prior claims. And that'll trigger, further investigation into what these claims were for and whether the claimant could have potentially injured an overlapping site in the past. And, it might not always reveal if the claimant had something that wasn't filed or, wasn't a claim, but he had an injury or whatever, but it at least gets the ball rolling. The next thing you're going to want to do is review the initial medical records and determine if any records are obviously missing. So sometimes you'll see a bill in the file without a corresponding report. In that situation, you might realize, oh, we're missing ER records or we're missing an urgent care report. Frequently, physician's note will state, the claimant visited the ER on the date of accident, followed up with urgent care, and then saw their primary care physician. Well, where is all that? We want that information because it's going to probably, in most situations clear up this issue and sort of reveal to us what prior issues did this claimant have, because it's not in evidence right now, but we know that there's medical out there that'll probably bring it into evidence. And then sometimes, the early treatment notes will simply reference a prior injury or illness and say, in 2013, claimant suffered a fall, not at work or whatever, and, it resulted in surgery. Well, the claimant should have reported that on the C3. And then another thing, this is a very common Easter egg that comes up frequently in relation to this issue, but also other issues, is sometimes the initial treatment records use language such as follow-up, and that can open up a whole can of worms, usually to our benefit, because it's like, where is all this stuff? We obviously need this if we're going to litigate this claim. So,
or it starts with the patient returns.
Mm-hmm.
Like, how can you return if you haven't been there before? How can you follow up if you haven't been there before? If they've been there before, it's usually for another condition, sometimes the same one, sometimes something pre-existing. Sometimes it's different. Sure, maybe nothing comes out of it, but boy, it's funny. It's funny when you find out that this person's come back to treat with the same doctor that they've been treating with for a prior condition.
Exactly. Yeah. No, I mean, it's a very common Easter egg, and what you can do with it varies from case to case. And this is just one example where they lied on the C3. But the third thing you're going to want to do is request testimony in some instances. Let's just get it on the record. Is the claimant denying that they didn't have prior treatment for an overlapping site? So this could lead to a number of things. Most commonly, it could lead to discovery of a pre-existing condition, which can trigger possible apportionment if it's established, or a possible argument against establishment if it's still a controverted case. And in some instances, it could result in a fraud finding under Section 114A. Remember what I said earlier is that fraud can sometimes just be an omission. Claimant thought they were slick by not answering the question, but the question was asked, and it's pretty clear that the claimant here, say they had a right knee surgery for a motor vehicle accident. I actually had a case like this, 4 or 5 years before the accident. You're saying, and now they're claiming the same knee in their comp claim. You're saying you didn't remember that, or you're saying, that you didn't think it was relevant to mention that you injured the same knee that you're claiming in your comp claim in the past for a significant motor vehicle accident that resulted in multiple surgeries to the knee. That can be fraud. It's a material omission of a relevant fact. All right, and next up we have reviewing the list of medications on hospital records, doctor's reports. They come up in certain things. Not all doctors list the medications being taken exhaustively. Usually hospital records do. And it's important to pay attention to the medications listed on the hospital or the urgent care records early in a case, because sometimes it'll reveal a pre-existing condition. And it's very common that the medications can be relevant when a claimant raises mental issues. All right, so we've got two separate scenarios here. The first one was a case that I handled and am still handling. Claimant raises PTSD and depression in a claim that was established for the back. The claimant alleged that the accident caused her to develop these conditions and that she began having panic attacks as a result of the accident. However, the psychiatric notes and the hospital records list anxiety medications for panic attacks the primary care provider had prescribed to the claimant well before the date of accident. Now, obviously, I think, on its face, you can see that that's going to raise some red flags. And we'll get to, the possible results in that case coming up. But the second scenario, claimant undergoes CT myelogram.
We got some feedback again. Okay.
Feedback?
It seems like every time I talk, it goes away. Sorry.
I don't know. I'm using my mic, like the fancy mic. But
yeah.
All right. Claimant undergoes a CT myelogram, and then after the fact, claimant suffers a stroke and alleges that the roughly $250,000 in hospital bills are related to the myelogram. However, by saying that it's related to the myelogram, they're saying it's related to my comp claim. The carrier should be liable for this massive amount of bills. Close review of the hospital records reveals that the claimant took 4 to 5 birth control pills after the myelogram. Now, how does that prove to be relevant? So I'm actually going to start with the second scenario here. Testimony of the IME toxicologist reveals that too many birth control pills can result in strokes. The doctor who performed the myelogram says that, yeah, in all my years of practice, no one suffered a stroke as a result of a CT myelogram. And ultimately, the carrier is found not responsible for the roughly $250,000 in bills, all because the attorney reviewed the medications. The list of medications showed, what happened here and why it happened. So it's very important to look at those. It's not always going to result in, discovering something crazy, but it could shed some light on the case. And in the first scenario, we have a possible fraud claim. And at the very least, we have stronger defenses to the claims for PTSD and depression and ammunition for the IME. So if we get an IME, we can just say, review these records. They show that the claimant's been on this medication since this date. What's your opinion on causal relationship with the alleged PTSD and depression? And like I said, even if we don't get an IME in that scenario, that evidence, the medications taken is in the record, and we can use it to support our defense. Okay, and I think this is the last Easter egg, and this is one of my favorites because it comes up way more often than you might think. It's something that I think every attorney at LOMAD is very keyed into, and probably the most fun part about it is that claimants' attorneys are almost never equipped to deal with it. It just seems to be an issue that they don't anticipate. It's just a matter of whether the judges will be receptive to it, but it's the type of thing that can also lead to pretty simple appeals. So the scenario would be where a treating provider only saw the claimant 1 to 2 times before issuing an evidentiary opinion. So the scenario here would be that the claimant treats with one doctor throughout the majority of his or her case, and then suddenly the claimant sees another doctor 1 to 2 times, and that doctor, on the second or third appointment, issues an evidentiary opinion. Now, an evidentiary opinion could be any number of things. Probably the prime examples would be SLU, permanency, causal relationship, degree of disability. And this is very significant. So it's not a given that just because the doctor is under the moniker of a treating doctor and not an IME doctor, that the board will consider the doctor to be a treating doctor. Essentially, there's tons of case law saying that a doctor who sees the claimant solely for the purpose of issuing one of these evidentiary opinions can be found to be the functional equivalent of an IME doctor. Now, that's important because, as you'll see in one of the next slides, IME doctors are beholden to very strict rules and regulations on how the reports need to be submitted, produced, information that needs to be included in them. Otherwise, they'll be precluded. And treating providers aren't held to these same rigorous standards. And the thing that's especially significant about the case law is while it's pretty obvious when a claimant goes and sees a doctor one time for an SLU opinion or some other evidentiary opinion, some doctors are smart, and we're aware of a lot of these doctors, and there's case law basically solely addressing these doctors' practice. Some doctors try and trick the system by seeing the claimant 1 or 2 times as a pretext. And there's case law saying that that also doesn't cut it. They need to be really providing treatment to the claimant. So the way that the board's rules define an attending physician versus an IME is an attending physician is someone who has the primary responsibility for treating the claimant, for the injuries in their comp claim. However, an IME is like Oh, go ahead.
Nope, I was killing the feedback. It had just started again.
Yeah, no.
What was the name of the doctor that does this, by the way? There's somebody that does this all the time.
One of the Dr. Hesch's.
Yes.
Yeah. And then an IME would be a doctor who provides an evidentiary opinion. So here's a list of what would be considered an evidentiary opinion: SLU, degree of disability; MMI, ability to return to work; permanency; appropriateness of treatment; necessity of treatment; proper treatment; extent of disability; second opinion, or any other purpose recognized by the board. So it's a pretty exhaustive list. And it means that this issue can come up in more scenarios than just scheduled loss of use, which is probably the most common. So, as I stated earlier, when a treating provider qualifies as an IME doctor, so it's found that yes, this doctor did not provide any treatment to the claimant. They solely saw the claimant for the purpose of issuing an opinion on scheduled loss of use. Well, guess what? That means they're beholden to the standards that IME doctors are beholden to under Section 137 and Board Rule 300.2. Otherwise, the report's going to be precluded. And I can tell you now, none of the treating doctors who do this comply with Section 137. So it's pretty much going to be an automatic preclusion. In fact, Dr. Hesch is a great example. He writes in his reports, this is not an IME. So, I mean, it's pretty clear evidence that he's aware of what he's doing and what, that he's trying to game the system. So under Section 137, one of the main things, and this is usually where you'll get these doctors on this, is that the report, so in this case, they're going to file it as a C43 instead of an IME report, must be submitted by the physician to the board, the carrier, claimants, treating doctors dating back a certain period of time, and the claimant on the same day and in the same manner, meaning all those copies need to be submitted at the same time. And if they're submitted, via fax, they all need to be submitted via fax. So otherwise, if they don't comply with this, there will be preclusion. So how do we proceed in this scenario? So usually what we'll do is we'll take the doctor's testimony. Now, sometimes you can run into an issue when you're seeking preclusion if you request the doctor's testimony. But what's unique about this scenario is that more evidence needs to be gleaned from the deposition to determine to what degree the doctor treated the claimant that probably can't be determined solely off of the reports. So we have the right to request testimony, and we won't be found to have waived the right to request preclusion. And the case law varies, and there's plenty of instances where the board finds a way to hold the doctor provided treatment in the limited amount of time that the provider saw the claimant. So the deposition requires some extra work. There's going to be a lot of thought put into how you're going to proceed. There's going to be on-the-spot decision-making, and you're going to need to think about, how do I want to show that this doctor didn't really provide any treatment without also giving the doctor the opportunity to basically fabricate evidence that they treated the claimant. And once you're satisfied that you have, proven that this doctor did not treat the claimant, or that enough evidence has been produced to that effect, on the record at the deposition, you must request preclusion of the doctor under Section 137. And, the result here is that we have a very strong argument for preclusion. It's pretty cut and dry. It's just a matter of the facts being weighed in terms of, did this doctor actually provide treatment or not? Worst case scenario, because judges don't seem to like to find this, we have a solid appeal on our hands, and sometimes they'll just discredit the doctor, which, if it's an SLU argument and they discredit the doctor and then find in favor of our IME doctor's SLU opinion, we basically won off of this argument, even though they didn't officially preclude the doctor. And then, that's something you can raise in your appeal or your rebuttal if claimant's counsel appeals the scheduled loss of use finding based off of the treating doctor being discredited. So, just think of the possibilities here. If the claimant's scheduled loss of use opinion is precluded, the board generally must automatically accept the IME's SLU opinion. They can correct it if it's wrongly calculated, but that's rare with IMEs. So this is a pretty huge Easter egg, and it's a fun one to deal with on our end because, like I said, it's the type of thing that tends to catch claimants' attorneys off guard. So yeah, I mean, that is our final Easter egg. I'll open it up.
I just want to add real quick too. If you can prove that it's an evidentiary opinion, you may not have to pay for it. So if you still have time to object to the bills, I mean, the regulations say we're not required to pay for the claimant to get their evidentiary, like an opinion for evidentiary purposes only. So those doctors could be hitting the pocketbooks too.
Yeah, that's a great point. So yeah, I'll open it up now. Questions. We got some information here. If you'd like a copy of today's presentation, you can email Kelsey from our office. Any other questions, feel free to contact me. My email address is provided at the bottom. But are there any questions?
I want to know if we all get Cadbury eggs for listening to the presentation.
It was really great.
This is a great one.
Yeah, I'm very impressed. This was wonderful.
Thank you.
All right. Well, I haven't heard no questions. It's 12:52. It is a Friday. Everyone wants to go home, right? Not LOMAD attorneys. They're working at all hours. But for the rest of you, enjoy your weekends. And remember, don't get angry. Get mad.
Thank you, James and Brendan.